Well, the short answer is no, because the individual's contract of employment will stipulate their working hours. And if the contract, for instance, says that the individual is going to be working from 9 a.m. to 5 p.m., then an employer and the employee's colleagues are entitled to expect that the individual is going to be available between 9 and 5. So if the employee wants to deviate from that, the employee will need employer's consent. But essentially, the individual is meant to be working in full during their working hours. Now, the individual's contract employment will normally stipulate that the individual can take a certain period of time for lunch, and by law, the individual is entitled to 20 minutes in a 6-hour day. However, the contract employment often provides for longer than this, and typically individuals are allowed a 1-hour period for lunch. Now, sometimes individuals say, well, that's okay, I'll take my lunch period and I'll go and do the school run at 3 p.m. or I'll go and do the dog walk at 11 a.m. But the cue is in the fact that the entitlement is to a lunch break. And so it's usual to expect that that is taken during lunch. And if there's any doubt about what period that means, then the employer can stipulate that in a policy or by a simple communication. But ordinarily, the expectation is that individuals will be on lunch between, say, 12 and 2 or thereabouts. So if an individual decides they want to do school pickup, and maybe that's at 2:30 or 3 o'clock, or they want to walk the dog, say at 11 a.m. in the morning, then employers may find that colleagues find it difficult to manage their own timescales around that and perhaps workplace planning and the like, and so may not be happy about that. So the best way to deal with that is to speak to the individual and say, look, you're never available at this particular time. Is there a reason why? Because we like to have calls and you're meant to be working during that time. And if the individual says that they've got some sort of commitment, as I said, like maybe the school run or they're walking the dog, then the employer and the employee could agree that as an informal process that the individual can take that time during the day to do that. However, the employer doesn't necessarily have to consent to that. And if the employer says, well, actually, we're not happy about you doing that because it interferes with work with your colleagues, for instance, and you're meant to be working at that time, then the employer can say, well, then you should put in a formal flexible working request. And again, the employer is entitled to reject that formal flexible working request if there's a reason to reject it under one of the grounds upon which employers can object to flexible working requests. So again, employees aren't entitled to just take time out in the day without permission. If an individual's working in the office, you wouldn't expect them to disappear at, say, 11 or 3, and the same rule applies where someone's working from home. So if individuals are perhaps taking time out to undertake regular activities like the school run, which they're committing to on a regular basis, then it might be advisable to raise that with their employer, because it's usually better to deal with it openly and transparently than to wait for the employer to discover that the individual is taking time out without consent.